Revoking your bond. Did you go to jail? I'm sorry. Bond conditions, bond conditions. There's no justification, right? You reopened cases. I've repeatedly told you, no tolerance, and you're just doing whatever you want to do. You're not charging it. Goes dead. So does the bond.
It went dead on the 10th, and he immediately went in to go have it checked out because
No, he didn't. No, he didn't. 2 days later, because you said you got to come to court, it's probably a good idea for you to go get it checked out. I don't know what more of no tolerance you don't get. Your device has been dead.
So Judge, I don't think it was low, and then it went dead for, I think, a couple of days, but he didn't receive. Well, I understand that, Judge, but he didn't receive, I guess the device supposed to send something.
You know when you're supposed to charge the device. You know.
I think it gives you a notice or something that is dying out. And so it didn't give him notice. So he went to pretrial service to have him check it out to find out what was going on with it. But he's been on bond for a very long period of time with no issues whatsoever.
That doesn't give you the justification to do what you're doing.
Just to take yes.
Judge, I will say that I contacted the device people over at 49, whenever he reported yesterday. They stated like
He only reported yesterday.
yes, we observed.
Unacceptable. Unacceptable.
Well, no, Judge, he reported because I told him that the device, that this was filed. That's the only reason why he reported over there.
The only reason he cared enough to go was because you told him he had to come to court. Otherwise, it would still be dead. It would still be non-functional.
I don't think that's the case, Judge, because it's been functional the entire time that he's had the device. So this is not he's been out for 2 months and the device has not been functioning. That's not it. This was just filed 2 days ago.
Because I wanted to take care of it now. And the reason is that he's on probation for a violation of protective order, picks up an assault of a pregnant person, and then picks up another assault of the same person. And he has another assault dismissed, and they're all the same person. And I told you that there was no tolerance in these cases. And I have here that you have a dead battery since 2/10 of how long was the battery dead?
According to the viewer, I believe it started on the 10th, and then whenever he reported for.
Yes, Judge, that's what I'm saying.
Reported for inspection, we found no issues with the device itself or the charger.
Revoking your bond. Did you go to jail? I'm sorry. Bond conditions, bond conditions. There's no justification, right? You reopened cases. I've repeatedly told you, no tolerance, and you're just doing whatever you want to do. You're not charging it. Goes dead. So does the bond.
It went dead on the 10th, and he immediately went in to go have it checked out because
No, he didn't. No, he didn't. 2 days later, because you said you got to come to court, it's probably a good idea for you to go get it checked out.
That's not how it happened, Judge.
Tell me.
When I got the email, I said, hey, there's an issue possibly with your device. He said, I got no notification whatsoever that it was dead. So I will go down there and check it out to see what's going on. I didn't tell him about a court date because I didn't know about the court date at the time. I got the motion first. Then your letter came after the fact. So he went on his own to have it checked out. So if you look at the records, I mean, he's been out for a while and this just happened. 2 days, that's it, Judge.
They tell you that you're supposed to charge this thing on a daily basis. They tell you that you need to put it by the charger every day for a specific amount of time. And if you don't, the battery goes dead. So you know what you're supposed to do.
I said it, Judge, but also if the court remembers that he is also keeping a newborn baby, so maybe he put it in.
That's
He was tired. I mean,
it's been dead for 2 days.
it's only been there for 1 day, I believe, Judge, because he went on the 11th, I believe. Today's the 14th.
No, she said yesterday he went. Today's the 14th. That's the 13th.
I'm sorry, that was the 12th. I don't know why I thought it was the 13th.
So when did he go?
The 12th.
No, the battery goes dead on the 12th. When did he go to pretrial?
He went to pretrial on the 12th, Judge. His battery went dead on the 10th.
Oh, I'm sorry. Okay, battery goes dead on the 10th. Goes to pretrial on the 12th. So he's without a device 2 days. I'm sorry. Goes with you. Just not getting it. I don't know what to tell you, Ms. Jewett, right? There's just no justification. I have 4 kids. You know, it'll take me 2 minutes to put them in front of an iPad for me to go do what I need to do to go wash the dishes, to go take the dog out, to change the litter.
Well, I understand, Judge, but
There's no excuse. You've got 3 open, very serious cases. And I told him at the outset when he picked up the last violation of protective order, there's no talk. I mean, you must comply strictly. And he's just not doing it.
it's gonna reset it for reconsideration on this bond, maybe 2 weeks of month.
So here's the deal. You were right. These cases are ripe. They're old. And it's time to do something with them because the thing is, and what I've experienced is that when we take too long with cases, something invariably happens. You know, cases should only last so long because certain people need certain things. And when they're not getting it, they tend to fall in familiar habits. So these are too ripe. Let me see how old these are.
And you remember, this case was actually transferred over to, the,
Irrity.
yes,
Right. Now I'm gonna keep it now, just because it's, just too much drama. So the violation case is 256 days old. The new violation case is 136 days old. Is discovery complete in both cases, please?
Yes, one confirm. Sorry, his last
The
name is
newest case is discovery complete.
correct?
yes, and Judge, if you remember, you may not remember, but this is the case where the wife is saying that what occurred is not really what occurred. Remember, this is the toxic case.
And Judge, either way, discovery is complete on the case.
Do you have an offer on these cases?
On the most recent VPO, there is not. Let me see if
Yeah,
Can you please put an offer so we can,
I'll let DVD know that you're requesting that they put an offer on.
Thanks.
Yes, Judge.
and is there an offer on the felony case?
On the felony case, Your Honor, let me see. There is not, Your Honor.
because the problem, Judge, is they were supposed to be working on the fact that the wife came to court and told the prosecutor she's not participating. So they were gonna reeval. That was 2 months ago.
If I may, they did offer him a 2-year deferred upstairs.
Oh, they did?
There, yes, Judge, it's just in the notes, not in the actual, they were having a conversation about going back and forth with the defense attorney on that case
Okay.
to see what they want to do.
So you're set up there 228. Okay. We can set the day after if you'd like.
That's right.
Okay. And then what I would suggest is when we come back, it's, plea or trial time. So we can just put these babies to bed once and for all. And perhaps the felony court will, you guys can make a global resolution. I don't know, but it's, if I don't do what I'm doing now, I'm enabling. And I'm saying it's okay for you to do what you're doing without any consequence. And it's not. He has to understand that there's consequence. This is the 4th time, it's over and it's over and it's over. And I can't.
That's it, Judge.
And I understand that you have to zealously advocate, and I'm not begrudging you for doing it, right? Certainly not. Of course not. But I can't continue to enable him, So, okay, you got it.
Which case is Jacob?
Mr. Ajete, you were charged with liquor sale without a permit. You are facing up to a year in jail and or a $4,000 fine. You are on bond for the same case. You've not picked up another case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On February 7th, 2025, the officers conducted an undercover vice investigation at a club known as Poppy's for operating illegally by selling alcohol without a permit and during prohibited hours. TABC confirmed that the establishment does not have a permit, and the undercover officer observed the defendant working as a bartender. The officer was able to purchase and order a vodka drink. After the officer gave him money, the defendant began to prepare the beverage.
So he's working after hours, you saying?
Yes, Judge. And he was also working at an establishment that does not have a permit.
All right, Mr. Ihete, I'm going to find that there's probable cause to go forward with the case. I asked you to do one thing, not to pick up any new cases. This is now your third of the same case. I am now revoking your bond and I'm putting you in jail. Goes with you. 5,003. It goes with you. Sorry, counsel, I can't just let it happen.
I
It's just
understand.
over and over and over.
At
some point he'll get it.
Dismissed.
Hmm?
The first one was dismissed.
I understand, but he's on bond for one, and now he picks up another one. So we're still over and over and over. At some point, you're gonna get in life, when you do the wrong things, there are consequences. And I can't continue to let it happen. It goes with you.
So
Yeah, just the old, so I'll leave the new case as is. The bond is at $500. On the case where, on the old case, I'll 5,000 and 5,000. Yeah, 5,002. He will pop up probably on Monday's docket unless he bonds out. I don't know. So if you want to pop on by Monday, we can talk about it and see where we are.
Okay,
Yeah.
thank you.
Thanks.
On the Taylor amendment you took in, he was already at 2501. Do you want
You were on bond for a theft case, and now you picked up another theft case. You now stand charged yet again with another theft. You're facing another 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, the complainant observed the defendant trying on sunglasses in their store in the Galleria Mall. And after the defendant left the store, the complainant noticed the sunglasses were missing. The complainant then reviewed surveillance in which he was able to see the defendant putting the sunglasses in his front right pocket and leaving the store passing all points of sale. The complainant then flagged down an officer who was able to locate and detain the defendant. The defendant was wearing the sunglasses on his face and admitted to concealing them. The sunglasses were valued at $350.
Mr. Taylor, I'm going to find that there's probable cause to go forward with your case. I am now revoking your bond on the first case. Goes with you. Unacceptable. We will not continue to give you PR bonds. This is your third one. No more. I will appoint you a lawyer today, but you're staying with me. No going to the gallery at all. Was the prior theft at the Galleria as well?
It was at a CVS, Your Honor.
Okay. No going to any CVS's, and I don't want you at the Houston Galleria. Do you understand? If I find that I don't know if you're going to get out. You get out, you pick up a third case, I'm going to go absolutely nuts on the bond. Do you understand? Goes with you. Do you mind filing those conditions on Williams?
Yes, Judge.
Good morning, Mr. Husband. You are charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On February 9th, 2025, the officer was dispatched to assist the officer call in regards to a shots fired at 1700 Travis Street. The defendant was detained because the officer observed an unidentified individual discharge a firearm and the defendant was within that group of people. The defendant admitted to the officer that he had 2 ecstasy pills in his right front pocket and that there was an AR pistol in the SUV the defendant was driving. The officer completed a search of the defendant and located 2 methamphetamine pills in his front right pocket. And the defendant informed the officer that he was aware of the AR pistol in the SUV prior to him getting behind the wheel. The officer located the AR pistol on the floor in the second row of the SUV within reach of the driver. The substance was believed to be methamphetamine based on training experience with a weight of 0.61 grams.
Husband, I'm going to find that there's probable cause. Wait a second. He says that the AR is his.
He says he was aware that it was in the vehicle
McKelvey?
and it was within his reach in the vehicle.
Whose vehicle is it?
I don't believe it says in the DMs, it says he was driving the vehicle.
How do you put it on him?
Allow me to read the full DMs, Your Honor. Yes, Your Honor. It says that he was driving, so it would be that he was in care custody control because he was operating the vehicle with knowledge that the firearm was in there and it was within his reach, his ability to grab the firearm.
Diego Camacho?
Not. How do we know that how do we know that it was in there while he was driving? How do we know that they didn't put it in there after the fact?
The defendant stated that he was aware that the AR pistol was in the vehicle before he got into the driver's seat, before he started driving.
Oh, no. It just said that he was aware. Don't add stuff in.
I'll read the complete DIM.
Read it.
It says the DIM states completely that the defendant informed the affiant, the officer, he was aware the AR pistol was in the SUV prior to him getting behind the wheel, and the defendant informed the officer that the AR pistol could be found in the SUV at the time of his arrest.
Are we to assume that it's his? All he says that he knew that it was in there. You know, it's not his car.
In Your Honor, just as cited, the pleading is that it was on or about his person. So we're just saying he was in his possession because it was in the vehicle he was operating with knowledge that the AR was in the vehicle as well as it being within.
Do you even know when he was operating the vehicle?
I apologize. What do you mean when he was operating?
Was he operating it in the morning, in the afternoon, at 9 o'clock at night? When did all this transpire? What time of day is this?
Let me see, Your Honor, because based on the DIMs that I see, it appears that
There's a group of people.
it appears that the defendant was, according to the DIMs, the defendant was found to be at the wheel of a black GMC. So when the officer arrived, he was observed within the vehicle from what the officer says.
Was in the car at the time
At
the
the
cops
time.
get there.
From what the officer says, that he was observed behind the wheel of the vehicle. To be at the wheel of the black GMC Suburban bearing a license plate number that is in the DIM. So
Okay. All right. Mr. Husband, I'm going to find that there's probable cause to go forward with your case. I mean, we take it seriously. I want to make sure if there's enough probable cause that's, so I am ordering you as a condition of your bond not to be in possession of weapons. Do you understand? If I find that you're a danger to my public, I only have one place for you. So don't. That includes everything. Do you understand, Mr. Husband? You mind filing no weapons, please?
Yes, Judge.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're ducking, you're dodging, you pick up a new case, it's not going to go well for you. Do you understand? All right, I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box. I get your bond conditions. We'll have you sign it, and then you're free to go. All right. Morning, Mr. Benjamin. You were charged with driving while your license is suspended. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On February 3rd, 2025, at 11:40 a.m., the officer ran a license plate search on a vehicle and found the vehicle to have expired registration. A traffic stop was then initiated. The officer notified the defendant for the reason of the stop and asked for the defendant's driver's license. The defendant provided a Texas ID that did not belong to him, and the officer asked for a name and date of birth. A search of the information provided showed the defendant's driver's license to be ineligible, and the vehicle also did not have valid insurance. And the officer did a person search on the defendant and found the defendant had a bond condition for an ignition interlock device, and that the vehicle did not have the interlock. The vehicle was registered to the defendant.
Johnson?
Let's go through your stuff. And I'm just from 2009. DWI, possession of a controlled substance, robbery, theft, possession of a controlled substance, felony theft, felony theft. Here's my concern. 2018, DWI second. 2019, DWI second. 2019, possession of a controlled substance. Further in the year, DWI second. Possession of a controlled substance, and now another DWI, and now driving on a suspended. I don't know if you watch the news. Every single day, someone dies from an alcohol-related collision in our county. Every single day. Watch the news. It's really, really unfortunate when a button on a phone and $30 on an Uber will get you to anywhere you want to go in this damn county. Don't matter where you want to go. It's a geographical oddity. It's so easy to just hit one button. I don't know what we need to get through to you, Mr. Benjamin, but I don't know if you're going to bond out. You will be signing an affidavit with me today, promising me you're not going to drive. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. Every single time you get behind the wheel, you can be facing 6 months in jail and up to 6 months in jail and or a $500 fine. Do you understand? Do not drive. It's really scary what happens every single day in our county, and it's so tragic. Don't drive.
Williams.
This is the promise that you're going to make to me. All I'm begging you to do is don't kill someone. Please, don't kill someone. You're being held at no bond on your DWI third upstairs as it is. And I don't know, right now they gave you a PR bond in this case, and I don't know if that's appropriate because you scare me. You just, according to this, I find by clear and convincing evidence that you just refuse to comply with bond conditions. So I don't know if I'm going to give him a PR bond. You know, he's driving a car here. He's supposed to have an interlock. He doesn't have one. And so I don't know. So for now, I'm going to have you sign the affidavit. It is a part of your bond condition. Don't be a danger to my county. Otherwise, I will make your bond very, very high. Do you understand? Get a clue, Mr. Benjamin. It's not hard. Come on. Are you Blake Long? Mr. Long, you're charged in 2 cases. You're charged with possession of marijuana. You're also charged with unlawful carrying of a weapon. You're facing up to 6 months in jail on the weed case, and you're facing up to a year on the gun case. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 8th, 2025, the officer observed the defendant's vehicle driving west on Sam Houston and ran the Texas license plate of the vehicle through NCIC, TCIC. The officer found a return came back with the registration expired as of September 2024. A traffic stop was then initiated and the officer made contact with the defendant, the driver, and sole occupant. The officer observed a strong odor of marijuana and could see a green leafy substance in a pocket behind the passenger seat. The green leafy substance was in a clear glass jar, and the defendant stated he was driving to his grandmother's house and stated he had just smoked. The defendant stated there was marijuana in the back seat within arm's reach and that the marijuana was for his grandmother. The defendant further stated there was a 9mm handgun inside the middle console area, not registered to him. The officer searched the motor vehicle and located the glass jar containing a clear bag with green leafy substance in the center console area and the 9mm handgun inside the middle console. The substance was believed to be marijuana based on training experience with a weight of 12.1 grams.
So long, I'm going to find that there's probable cause to go forward with the case. Can you run his license, please?
It's eligible, Your Honor.
Okay. You're not allowed to drive unless you also have liability insurance. Do you understand?
Yes, sir.
That is a bond condition of yours as well. Do not pick up any new cases. I don't want you in possession of any weapons at this time.
Yes, sir.
Understand?
Yes, sir.
Do you have the ability to hire a lawyer?
No, sir.
Okay, I'll have you fill out an application to see whether you qualify. I'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We'll have you sign the bond conditions and I'll have you meet with a lawyer here momentarily. Okay,
Judge,
please.
was that state sponsored?
States, yeah.
Um,
I don't think you qualify for an appointed lawyer, man. You just make too much money, really. Do you have any children?
I have two children I put on there, 2 and 1. The only income for the household.
You married?
No, sir.
Do you get support for the children?
No, sir.
All right, I'll grant it.
Thank you. Thank you, Your Honor.
Anybody else? I'm going to run to court 3 real quick.